All right, thank you all for attending our second round of virtual landlord trainings. Just a couple things before we get started. Please leave your microphones muted and your video screens off during the presentation. Also, if you need a certificate for participation, please email or contact Marilyn and she will get that out to you. But for our first presentation of this second round, we have Mike with the Department of Labor and Human Rights, and he is going to be discussing fair housing. So turn it over to you, Mike.
Thank you very much. So like Kylie said, my name's Michael. I've been with the department about 4 years. Before that, I worked for the Nebraska Equal Opportunity Commission doing housing investigations and training. So I appreciate being here today. I've got a little slideshow set up. We'll kind of go over it throughout. If you have questions, I'll try my best to leave some time at the end to answer any questions. So what we'll be doing here today is going over the department scope. That just means what we have jurisdiction on. I'll give some statistics. I think statistics are good. Whenever you're looking at trends, especially with laws and stuff like that, we can see what's been filed on, not just in North Dakota, but also federally. We'll go over the fair housing laws, answer the question, what is discrimination? Go over some common issues, and throughout, I'll be trying to use my role as an investigator to explain how these things work from our department's perspective, especially that of an investigator. So the scope and statistics. The North Dakota Department of Labor and Human Rights is a neutral enforcement agency with basically 3 primary functions, and they're wage and hour, the Human Rights Division, and then education and awareness. Where housing falls in is in the Human Rights Division, also public service, public accommodation, and credit transactions, which also could be possibly housing, also fall into that Human Rights Division. Wage and hour, this used to be our big component of what we do on a daily basis, but we have seen those cases level off. After the oil field kind of boomed here in North Dakota, we saw our cases in that aspect really take off. So now it's pretty equal where we get to spend our time and kind of what we do throughout the day. The Human Rights Division, there's the laws. It's the North Dakota Century Code 14 is the Human Rights Act. The North Dakota Housing Discrimination Act is also Century Code 14. We also look into Public Employees Relations Act and North Dakota Whistleblowers Act. Now, we can't actively investigate those, but we do have power to mediate or conciliate those as well. So those are part of what we do here with the department. We're going to be focusing on the North Dakota, Human Rights Act and the North Dakota Housing Act for the purposes of this training. As far as contacts for human rights questions, this is the last biennium. We had roughly 2,536 public contacts, 426 claims filed under the North Dakota Human Rights Act or the Employment Discrimination Act, as all falls under the Human Rights Act, North Dakota. 487 claims closed. The reason there is more claims closed is sometimes cases take a while and roll into the next biennium. We do track these, and we will be working on our next biennium here shortly, I believe this summer. So we'll have some updated numbers the next time around, but we only do this every 2 years. Housing claims for the last biennium, we had 43 disability. Retaliation, we had 6. Public assistance, which is a state-only violation, we had 4. And familial status, we had 4. Race, also 4. So that's how kind of things looked at. Now, the reason that number is a little different is because people can file under multiple bases. It could be disability and retaliation, could be disability and familial status, and we look at those Altogether, the average days to close a housing complaint is 63 days. So we try our best to get them done in 100 days. Doesn't mean that we always accomplish that goal, though. Here's the results of those total claims closed. We had 34 conciliated. Conciliated just means, the agreement was reached. It's not a finding or an admittance of guilt. The matter has been resolved. No reasonable cause, 15. And we had one reasonable cause case. Again, this is last biennium. We update these every 2 years. So hopefully this summer we'll have a new update. If you're curious about them, come to our website. We do post the biennium information on our website. Withdrawn with resolution is kind of unique to housing. It just means that the person that filed has withdrawn, but the matter has been resolved sort of outside a conciliated agreement. So that's the statistics. North Dakota. Now, when we look at North Dakota versus nationally, when you're looking at the basis or what the reason something was filed for, North Dakota #1 is disability. This also falls in line with HUD's 2019-2018 annual report. Their #2 was race. Retaliation was 3. We had kind of a tie for our third. Fourth was sex. They also had 15,553. They generate this number through cases not only filed with them, but also the cases filed with us that meet the jurisdictional requirements to be dual filed. So although we only had so many cases, there's obviously a lot more nationally going on. Now, also, of these cases filed nationally, 70% are going to be your terms and conditions, privileges of services, discriminatory terms, conditions, privileges of services. 43 are roughly reasonable accommodation. 28 to 27 are refusal to rent, and about 20 to 21 are retaliation. Now, you can also file on multiple issues. You can file on one issue. So it could be, I was denied a reasonable accommodation, but I was refused rent due to my national origin. It could be both. It could be one or the other. So that's why the statistics vary. But the trend has continued with disability increasing over the last few reports that HUD has put out. That's continuing here on a state level as well. We keep seeing disability increasing, and I know there will be additional presentations by other investigators in our department about reasonable accommodations, as well as service animals and things like that. I will touch upon some of that stuff, but I will leave the vast majority of it to Milena, who will be presenting in a few days as well. Roughly, total relief from HUD and FAPS, North Dakota Department of Labor and Human Rights, is a FAP. In 2019 was $16 million. In 2018 was $18 million. So again, total relief, you're looking at training, policy changes, monetary relief. They kind of combine all of that into their total relief number. So what is housing discrimination? And, well, we have a definition for it. It's treating someone differently in the sale, rental, publication, inspection, membership, and or access to housing because of a person's membership or association with a protected category. So, I mean, we say publication, inspection, membership. It sort of does boil down to sale and rental is a good way to, I guess, more concisely sum it up, but it is more than just selling and renting. It could be the publication, could be an inspection, somebody coming to view an apartment, membership, or access to housing because of a person's protected category, protected categories, or race, national origin, things along those lines. Can also involve financial transactions related to housing. We don't have a bunch of credit transaction cases. We do have a state law for credit transactions, but oftentimes when we see them, they would be in housing cases. Also important to remember that it's not only the individual's protected category, but their association with. It could be, due to their husband's national origin, their husband's disability, things like that. That's what we mean by association. They're associated with someone, and that's why they believe they're being discriminated against or treated differently. There's two laws. You have the Fair Housing Act of 1968 and the North Dakota Housing Discrimination Act of 1999. Now, we have a work share agreement with HUD, which means we are substantially equivalent, but there are a couple differences between state and federal law. And generally speaking, though, they're going to be pretty identical to each other. It also means that when we perform an investigation, it's going to be no different than if HUD was to perform the investigation and we adopt each other's findings. We do get audited by HUD, and they basically select a few cases. They'll speak to the investigator. They'll look at all the evidence we collected, and make sure that we are still substantially equivalent. This happened last year. HUD requested the documents. We sent them to them. They called us. They asked questions. They asked questions about our training. So it's not only substantially equivalent in the terms of an investigation, but also what we're doing. And for any reason, if we don't meet that substantial equivalency, we could lose that federal funding that HUD does give the department. So those are the laws. Now, who or what is covered under the laws? The aggrieved person is a member of a protected category. In housing, we use the term complainant. Employment, we say it is a charging party. Is the dwelling or housing related transaction covered under the law? Well, a dwelling under North Dakota Human Rights Act is any structure occupied as or designed or intended for occupancy as a residency by one or more families, or vacant land offered for sale or lease for construction or location of a structure as a residence. Now, the federal law says 4 or more units. So that's really the only difference between the North Dakota Human Rights Act as far as a dwelling, is that for federal law, 4 or more units. Now, anytime a publication is used, listing agent, advertisement, that automatically qualifies as a dwelling. Also important to note that a dwelling is also possibly homeless shelters, anything where the person has an assigned bed, a locker, it's more than one day, an extended day, transitional housing, could be also a housing dwelling. So it's not just, a single family home or an apartment. There are other dwellings out there. And so anytime a case comes in, that's pretty much the first step. As we get an intake, we're going to look at the dwelling. Is this a dwelling? Is there an allegation that violates the North Dakota Human Rights Act or Fair Housing Act? And if there is, we draft the charge. Now, there are a number of exemptions. We'll kind of go over exemptions later, Miss Murphy being one of them. However, even if the housing is exempt, if the advertisement itself violates the act, that could still be discriminatory conduct. So big thing to remember is dwelling or housing related transaction. That also includes publications and things along those lines, which we will go into here in a little bit as well. Protected categories under the Fair Housing Act: the race, color, religion, sex. Fair Housing Act prohibits housing providers from discriminating against applicants or residents because of their disability or the disability of anyone associated with them. Again, keyword associated, and from treating persons with disabilities less favorably than others because of their disabilities. So, we're looking at what this is, the why something happened when a case comes in. They believe the why was their race, their color, their religion. If they can establish that, again, the jurisdiction and a violation of the act, we begin the investigation. We do not have all the answers at the beginning of an investigation. So when you get a charge, from the department, or if you happen to be part of the charge, we're just looking at, is there enough to begin an investigation, basically? Is the minimal amount there? And that's kind of how all these investigations started. Under the North Dakota Human Rights Act, we do have a few other things as well. North Dakota says it's not unlawful discriminatory act to refuse to rent unmarried persons seeking to cohabitate based on criminal statutes, or statute has since been repealed. But the key here is you're going to look at receipt of public assistance, age, certain victims of domestic violence. Now, that also could be based on sex. And I have seen federal charges where it is based on sex. So again, there's a multitude of why things happened. And when we get a case, first step is, okay, they allege it. That's what it's going into. Now, one major update is that sexual orientation and gender identification. It is the department's opinion the Bostock definition of sex may and should be applied to the North Dakota Human Rights Act as amended and the Housing Discrimination Act as amended. Therefore, effective June 15th, 2020, the department will be accepting and investigating complaints of discrimination based on sexual orientation and gender identity. So we have updated all of our materials at this point to include that. This was a change for the department, as since the federal ruling came down, Commissioner Thunder signed the memorandum of understanding, and we have begun investigating these cases. As far as I'm aware, we haven't had any yet filed, but again, we have updated our material, including trainings, so that people are aware that discrimination based on sexual orientation and gender identification, the department has begun accepting those complaints. So, like I said, the majority of our cases are disability. I think it's important to then go over the definition of disability in any case we do. So the individual must meet the definition under the acts, and the acts are the North Dakota Human Rights Act and the Fair Housing Act. An individual who physically or mental impairment that substantially limits a major life activity, has a record of, or is regarded as having such an impairment. Now, those are the only acts that apply to housing. It's the Fair Housing Act, North Dakota Human Rights Act. The Fair Housing Act, as well as the North Dakota Human Rights Act, did not take into account any amendments by the ADA for who's a person with a disability. So that means we do look at mitigating measures. And if we have to make a determination, we do get that information and look to see if there are mitigating measures for when something has relieved that disability. We do look into those things, but that's the general definition, is those three key bullet points as well. And if you have questions on disability in the Fair Housing Act, there's lots of good resources from the Department of Justice, as well as HUD on disability and definitions and who meets that. So it can only be discrimination if the person has disability, right? No, it can be treatment because of his disability, treatment of a person associated with that person, again, association, and things like discriminatory statements can be illegal. Also, disabilities has a broad spectrum, and we do mean broad. It might not always be obvious. There's disabilities that are not obvious. Substantially limits a major life activity basically means a body system. So that was what makes it broad. It could be walking, sleeping, any of those things are a major life activity and are affected by a bodily system. So that's our definition of disability. Retaliation, this is another one of our big common areas. Even if cases aren't filed on this, in my experience, we get a lot of questions about it with people even contacting us. They fear retaliation. They worry that, hey, I contacted the department. Can I be retaliated against? So this is another thing that we try to go over with people, is that, retaliation is prohibited. And I should go back. The key definition for retaliation for North Dakota is going to be Century Code 1402.5, number 45. And basically what it's going to say is that, threats, intimidation, participation could be, requesting a reasonable accommodation, reporting harassment, participating in an investigation, being a witness, any, it's a broad spectrum. And again, like I said, when we get phone calls, if reasonable accommodation is not the number one issue, retaliation is probably close second. It's pretty common even outside of housing that people, again, do fear retaliation or being retaliated against. Some more common issues, especially with housing, is publications. And a person may not make, print, publish, or effect the making of printing or publishing of a notice or statement or advertisement that's about the sale or rental of a dwelling, and that indicates any preference, limitation, or discrimination because of a person's membership in a protected category. So what we're talking about here is, describing the person applying, not describing the property generally. We're going to go over some terms to avoid, but the big thing here to remember as we go into publications is we're talking about, describing a protected category, or words that may give a preference to a protected category or deter people of a protected category from applying. So some examples, published in newspapers or other media, any written statements, and then verbal and non-verbal statements. So we're talking about applications, brochures, signs, banners, photographs, spoken words and phrases, almost anything that conveys that the dwellings are available or may not be available to a particular group. And this also extends past just landlords. It could be advertising agencies, could also end up on a charge. Also be aware, if you are using an advertising agency, if you are the landlord, the managing partner, the owner of the property, you could also still be liable for what they are advertising about your property. So, that's an important aspect. So who's liable? Advertising media, advertising agencies, and all other persons who use advertising to make, print, or publish, or cause to be made, print, or publish advertisements, and even financing of a dwelling. I will say we do not get a lot of people that file against the advertising agency. I have seen a few, not saying that we could see an uptick on this, but when we get a case, they're going to list who they believe the respondents are. If they want to file against the advertising agency, we ultimately do file against the advertising agency and any parties that may be responsible thereafter. So the reasonable person standard in determining whether a publication constitutes a discriminatory housing practice, courts have generally applied the reasonable standard. So we're talking, this means that the liability is accrued by a person or entity if they make, indicates a preference or readily apparent to an ordinary reader or listener. Reasonable person, I would say, it really hasn't changed much over the history, because obviously people do change. But we haven't seen anything yet come down where the reasonable person standard has expanded to be more broad or gotten rid of. It's still used. So what that means is we want to look at terms to possibly avoid. So sex, single, two people, even executive, exclusive sometimes, integrated. We're looking at words that could possibly give off the notion of a preference or detour people from applying. Some more, membership, approval, mentally ill. It's not saying we can't, membership of itself is an issue, but it's how that word is used. Be cautious of emotionally charged tenants. Oftentimes we find these words when, they come in to do an inspection and, they start describing what tenant they would like living there. That's going to be leading to issues. Statements are also publications. So saying things like, there's no way I would ever rent to anyone who has a disability, or no way I would rent to, a Hispanic individual, or somebody on public assistance, those kind of statements, they're going to be problematic. I would say that most devices nowadays have recording abilities, have the ability to record whether you're aware or not. And oftentimes they come to us during investigations. So the general rule is going to be, when advertising the sale or rental of the dwelling, is not to describe the person, but describe the property. If you can stick to that, you're going to be in a much better shape when the cases do come to us. Now, those words always do expand, always do, change over time. But again, if you're describing the property, it's a good general rule to go by. And when people come to do in the inspection, again, describe the property, not the person you would want there, or the person that may be applying or generally lives there. Describe the property. So, are there exemptions? Yes. Certain sales and rentals are exempt. Miss Murphy being that for fewer rental units, and the owner lives in one of those units. The owner would have to be proven to live there. Generally, how this works in an investigation is, somebody comes to us with the bare allegations, we submit the charge. The owner has to provide a response saying, I live here, here's my information showing I live here, and therefore fewer rental units. Religious exemptions, I think that one's 1402.5, number 10. Private club exemption, but the club cannot be restrictive because of race, color, or national origin. It's a members type of thing. And elderly housing as well relates to familial status and age for developments that meet the requirement for housing for older persons. So those exemptions apply not only to publications, but also the Fair Housing Act generally, as well as the North Dakota Human Rights Act. It's always good, though, to just be aware that if you're renting a property involved in the rental or sale, that more than likely it's going to be covered under the North Dakota Fair Housing Act or the Fair Housing Act itself. So again, exemptions from publications, the housing for older persons, private clubs, religious organizations, and shared housing being the Miss Murphy. Little tidbit on housing for older persons: advertisements for the sale or rental of dwellings designated as housing for older persons may indicate the limitation of on age only, 55 or 62, depending on the designation, but it has to be designated as housing for older persons. You can lose exemptions if, yes, we're a older housing, but we're actually renting to other people. Those can cause you to lose exemptions. So again, although there are exemptions, it's best to always go in with the idea that the dwelling is going to be covered under the Fair Housing Act or the North Dakota Human Rights Act. So reasonable accommodations, again, I spoke about. There is going to be a presentation later by a fellow investigator, Milena, who is very knowledgeable and gives great presentations about reasonable accommodations. But they are a general common issue we see with housing investigations. So fair housing laws required reasonable accommodations for individuals with disabilities. Failure to do so constitutes discrimination on the basis of disability. So keyword, what is reasonable, right? That's basically meaning does not cause an undue hardship or interfere with the business operations. You know, extreme examples of undue hardship would be it's going to cost us $22 million to put in a specialized jacuzzi for the person with a possible skin disorder. Again, that could possibly be an undue hardship. What I would say is we in an investigation are going to look at those on a case by case basis. So just because you heard from Joe that they got an undue hardship does not mean in your situation it's an undue hardship. It's a case by case basis. It's up to the landlord to prove it's an undue hardship. Financial burden, administrative burden, require a fundamental altercation to the provider's operations. Even if the answer is yes, the landlord still has to engage in the interactive process. An example is tenant can't lift the lid to the garbage can due to his disability and request maintenance employee to come get the trash. Respondent states they could not provide this. The respondent is still obligated to provide an accommodation, an alternative accommodation, such as an open garbage can, putting the trash maybe outside the door. You don't have to give the exact accommodation if it's not readily apparent that that is the only relief. So engage in the interactive process. These are what we're seeing. Again, increase over time. I will also say from an investigator's point of view, if it is filed under reasonable accommodation, it's also filed under discriminatory terms, conditions, privileges, or services. Reason for that being is if you're denying somebody a reasonable accommodation, you're also treating them to different terms and conditions. So this will be closely and carefully looked at in a housing determination case. Again, engage in the interactive process, have a policy, have a practice, have communication throughout your chain. Know that if you don't know the answer, here's how I'm going to do it. Just because, you're a manager or the landlord or the owner, but somebody else denies a reasonable accommodation, you could still be liable. So always be aware of who is making decisions, what the policy is, and attend training. Reasonable modifications. Fair housing laws also require reasonable modifications to be made to the unit or common areas for individuals with disabilities. Same undue hardship. Examples: widening of doors to make room, accessible chairs, room under sinks, grab bars in the bathroom, kitchen cabinets. One I haven't seen in North Dakota, but saw frequently in Nebraska was switches. Being able to turn off lights, being able to turn on a garbage disposal. Those things are modifications. So be aware that, modifications could be a lot of different things. It's not just, one thing or the other. And again, the reasonable or undue hardship applies. If somebody wants you to build a new building because they have trouble getting into the bathroom. Obviously, building a new building, that's probably unreasonable. And also, some keys to take away from this is that a reasonable accommodation is a change to a rule, policy, or practice or service. It's cost paid by the landlord. Reasonable modifications generally relates to the removal of physical barriers. Costs paid by the tenant, cost paid by the landlord for federally supported programs. We'll go over that in a minute. A big key is requests neither need to be in writing or use magic words. Very few times. I will say though, in housing, tenants are generally better about coming to you and say, I need a reasonable accommodation. They do not have to say that though. You have to be aware that, they don't have to use specific language or possibly even fill out a specific provided form if the accommodation is readily apparent. And what I would say is also, it could be an accommodation and a modification together. One good example of this, as reminded to me recently, was changing of carpet to possibly a linoleum floor for somebody with a wheelchair. Yeah, that would be a modification, but if you also have a policy that says tenants can't change carpet, and you say, well, we have that policy, that would be a reasonable accommodation is, hey, can I change this? So, you know, be aware that there are instances where it can be an accommodation and a modification together. They're not separate. Don't think of them as competing ideas. They can be, generally seen though as, removal of physical barriers for modifications, and accommodations is a change of rule, policy, or practice. Now, very briefly, Section 504, that's what we're talking about with reasonable modifications when the landlord would pay it. So, and again, Milena will be giving a presentation on this information. So she will be going over that. And probably the biggest key takeaway I would say is that if it's 504, we're not going to look into it. As an investigator, HUD would have to look into it then. So can a landlord ask for documentation? The best answer, it's not even the short answer, is maybe. A housing provider may not ordinarily inquire as to the nature and severity of an individual's disability. So you're not looking at the severity of it, basically, is a very important part of it. However, in response to a request, for a reasonable modification, a housing provider may request or rely upon disability related information. So it's dependent. And as an investigator, we're looking at a case-by-case basis. We cannot say this disability, you absolutely don't need medical documentation. This disability, you absolutely do. It's not how it works. Again, I cannot stress enough, case-by-case basis. The big key takeaway is you're not doctors. So if you need more information, you may need to look into it. Now, if it is obvious, again, obvious being there's no doubt, no question, okay, then you may not be able to request medical documentation. So as landlords, are background checks legal? Yes. It is legal for housing providers to ask questions about applicants' background or require background check. However, anytime a housing provider makes a decision based on an applicant's background information, it must comply with federal and state discrimination laws. What that means, again, is basically it can't be a discriminatory question in the background check. It can't be, are you born in America? Things like that could be problematic in a background check. So what we're going to say is disparate treatment, disparate impact. Disparate treatment, treating a particular individually differently in how you deal with a criminal background check. What that means is, you let 4 or 5 go through with the same offense, but then this person didn't get through for the same offense. That information comes to us, we're going to need you to provide a response. It is difficult, to provide a response to those situations, and it's going to lead to an investigation. So having a consistent policy and practice is very important if you're going to do background checks or criminal background checks. Disparate impact is the housing provider's decision making or selecting process is neutral on the face of it, but has an adverse impact of a protected class under the law. So example, one situation, you ask an African-American applicant for a background check, but you don't ask this, a Caucasian applicant for a background check. There are testers out there. Testers will call They may self-identify. So again, having a clear and concise practice, policy, training, and communication within your internal group will help significantly. So, disparate impact, an example of that, is going to be on the claimant or complainant to prove, it has a disparate impact. So it's not one we see very often, but it is something to be very aware of. So HUD recommendations: develop a narrowly tailored written policy procedure for screening conduct or based on criminal conduct. Again, have a policy, have a practice. We stress it anytime we give a training, whether it's employment, wage and hour, or housing. Can't stress it enough. The policy should determine the specific offenses that may demonstrate unfitness for housing and the duration of exclusion for criminal conduct. Again, if it applies to one person, it's got to apply to the same person. It can't be tailored and things like that. So continuing with HUD recommendations, train your managers and decision makers on how to implement policy and procedures consistent with HUD guidance. HUD does send out guidance. All their guidance is available on their website. It is numerous, copious, and long, but be aware that, if you have training, you have a concise policy, it is implemented, it's consistent, you have communication, those are going to go a long way in possibly deterring any issues that may come to the department or any investigator. Delay consideration of criminal history until after an applicant's financial information and rental history are verified. Basically, make sure they're a qualified tenant for other reasons first. That's going to go a long ways. But even with that, based on that financial information, make sure it's implemented consistently. It's not varying, like credit scores below this range are automatically disqualified, or credit scores, above this are special. But then in this instance, we didn't do it. That's going to lead to an issue. Many of these factors are the same for any protected category analysis to try and avoid discrimination claims. Train your staff, especially those handling applications and interactions with the public. Goes back to discriminatory statements. If they're stating things that could give off the inference and deter someone, that's going to lead to issues with the department or with the Fair Housing Act or in court. Train your staff. Housing providers considerations: document the housing decisions and basis for disqualification. Is it done internally? Are you logging the results of the review? Establish a formal means of individualized assessment. Clearly state adherence to the fair housing laws and policies against discrimination. Document, document, document. Doesn't matter what kind of line of work you're in. If you can document it, support it, it's going to help in an investigation. We do request those documents in an investigation. Not having them, it's going to be problematic. The department does have the power to subpoena. What I say by problematic, it doesn't mean it automatically leads to a cause or no cause finding, but it's going to be time and effort to explain to us, well, on December 5th, you allowed Johnny in, but now you're not allowing Sam in. Where's the documents? Where's the reasoning? Where was it denoted? How was it communicated to the person? Have a consistent policy. When it's done internally, you're not relying on an outside agency to discriminate against them, because again, what their actions are could come back and make you liable also. So be aware of who's making the decision, why decisions are made, and documenting those decisions. Log it, document it, communicate it, goes a long ways. So kind of lastly, and I've kind of hit on it throughout the investigation. The role of the department as an investigator is conduct fair, impartial, and thorough investigations into the circumstances of the complaint. Every case is a case-by-case basis. If you have one case where we determined one thing, doesn't mean, the next case on disability terms and conditions is going to have the same finding. Case by case, facts matter. It's not the department's job to play a gotcha game. We're going to request documents from the beginning. We send letters from the beginning requesting documents. We collect the facts and circumstances. Is there a reasonable cause to believe the respondent committed an unlawful act of housing discrimination, or respondents, I should say? Treating someone fairly, not allowing persons' opinions to influence judgment. Both complainant and respondent are treated the same way with respect. We do not take sides. We may ask difficult questions and do ask difficult questions. But the reason we do that is because we need to know the facts and circumstances. So, just because you denied, like I said, Sam or somebody like that, we're going to ask why. We're going to probe. We want to know that this wasn't a violation. The thing I tell people is we're just as interested in finding no reasonable cause cases as we are reasonable cause cases. There's no difference to us. We treat every case the same way. So another role is that of conciliation. The Fair Housing Act, as well as the North Dakota Human Rights Act, does stress conciliation. It's also HUD's guidance that we stress conciliation. Conciliation is an agreement between parties. It's not an admittance of guilt. It's basically saying, okay, somebody came with this issue. Can we resolve it without a determination? So if it's a reasonable cause, or not reasonable cause, reasonable accommodation case, can we resolve that without a determination? Most of the time it involves some monetary amount, but it can also be, removing a barrier, presenting a reasonable accommodation to somebody, a neutral housing reference. All those things can see the matter resolved. Every investigator is also the conciliator. So we wear two hats is the best way to describe it. It's voluntary, but agreements are binding. We will follow up with them. We will request that you provide us documentation if somebody has to go to training, a copy of a monetary settlement. We will follow up with them. We do follow up with them. What I will also say is that there has to be a relief for the public interest for HUD to approve of the settlement. So what that means is, training generally, participating in fair housing months, things like that, that will not only see this action resolved, but future possible actions. It is a requirement from HUD, and as a conciliator, we do make parties aware of that. What I will also say is training through the department is free. If you want training, a group wants training, reach out to the department. We'll see what we can do. We also have brochures on it. HUD has brochures. Our department's website has some information on it. Go there. That can resolve a lot of issues before it even comes to an investigation. So conciliator, that's what we generally do. And, the agreement is binding, meaning that it's reviewed by the attorney. Our general agreements are reviewed by the Attorney General's office to make sure that the key points are there. They're reviewed by the Human Rights Director. And confidentiality, nothing said or done during conciliation negotiations can be used by a party in a subsequent administrative hearing or civil trial or even the investigation. So we keep it confidential. But I would encourage both parties, no matter who it is, that, conciliation can save you time, can save you costs, can resolve the issue, and can resolve possible further issues in the future. And it's not a one side is forced to do this, one side's not. So let's say all that fails, we go to determinations. If it's reasonable cause, we issue a charge. The complaint itself is not a charge, an official charge of discrimination. Basically, we'll make a determination, then we'll issue an official charge. They are reviewed, written by the Human Rights Director. The Attorney General does sit in on them sometimes. And that's where it could go to court. If elected, it could go to administrative law judge. There's lots of different avenues there. If it's no reasonable cause, we dismiss the complaint. So basically, even if we determine reasonable cause, that's not the end of it. So also, one thing conciliation does is if you think you're going to end up down that road in litigation, it resolves that time and effort. Although we complete cases in 60 days, these issues, when we get to a charge after a reasonable cause finding, oftentimes go much longer than 60 days. There's appeals and things like that. The charge is basically going to be a statement of facts, is basing the reasonable cause findings on. So you can sort of look at it as a summation. So what can you do? Get educated. Like I said, the department role, as said at the beginning, is to educate and awareness. The laws can be complicated. Reach out. If, Minot has training, if Dickinson has training, Fargo, try and attend them. A lot of these are going virtual with the new world we live in. It can go a long way into deterring any issue. It will also keep you up to date with issues and how basis has changed, like I mentioned today with sexual orientation and gender identification. Those are now protected classes in North Dakota. That information, although it's on our website, sometimes doesn't make its way through communicating to all landlords. We hope it does. So visit our website, visit with an attorney knowledgeable in fair housing laws. The department does not recommend any attorneys. We do not direct anyone that calls us to any attorneys. Department of Justice has information on fair housing as well. There's lots of information, and try to attend any training you can. Some department general recommendations is document. Doesn't matter, like I said, wage claim, housing, employment discrimination, document. Avoid sudden rash decisions. This again goes back to possibly applying the background checks, consistent policies, consistent practices. Take the time to think, evaluate prior to jumping straight to no or ignoring them. Again, Milena will be going over reasonable accommodations, but also ignoring somebody can be problematic. Know the law. If you don't contact an attorney with experience, be consistent. It says be nice. Can't always, unfortunately, be nice. What I will say is be consistent. That's, where we see issues is where things aren't consistent. Communicate, have a policy, have a practice. It's one thing to have a policy, but in an investigation, if your subordinates are detouring, from that policy with a different practice, that's problematic. Even though your policy is good, the practice is an issue. So that's why training is important and communication. So what does this all mean? We've reviewed some technical terms. I tried to give as much examples about investigations, how they work. If you call the department, we can't tell you what to do. We can tell you what the law says. Try and provide how an investigation will work. We don't provide, though, legal recommendations or what you have to do in a situation. The reason for that is we're neutral. We don't represent the respondents. We don't represent the complainants. We don't represent third parties. Be aware that laws change. Also be aware that guidance changes. If you have a Google alert, set up a Google alert for Fair Housing, Fair Housing Act, North Dakota Fair Housing. Things along those lines can go a long way and deterring possible issues. So I will open it up to any questions.
We do have a few. First one, can an RV be a dwelling?
Maybe. And again, I know it says maybe. It's gonna, RV parks can be, I guess, landlords' dwellings. An RV absolutely could possibly be one. Again, the example of a homeless shelter, if there's a bed, a locker, it's an extended stay, it's designated to someone, possibly. It possibly could. It also possibly couldn't, depending upon the circumstances behind the RV, who owns it, does the person own it, are you lot renting? Again, all those issues come into an investigation, but it definitely could be.
Okay. What would be some ways that people discriminate based on public assistance?
Public assistance is generally going to be receiving something like SNAP, things where the individual applying has received some assistance, generally speaking, again, generally financially from the state, federal entity, things along those lines are going to be your best examples for public assistance. Not saying those could change, it could be expanded upon, but that's going to be where to start with that one.
Does the tenant have to file, or can a caseworker file when they see discrimination?
Somebody can file for someone. Could be a family member, could be a representative. Whoever the harm is going to be the complainant. There's associated people or other people living in the household. They're not complainants, but theoretically, someone could. It could also be someone that spots a discriminatory advertisement publication along the way and says, I assist people with disabilities. This says no mentally ill people. That's discriminatory. I can't allow anyone to stay there. So although, it's going to be that association, they have to establish there's an association for that, and they could have a representative as well.
Okay. We try to do rental history verifications, but many companies will not cooperate any longer. As we are learning who those companies are, we no longer send rental history verifications to those companies. Is this a discriminatory practice?
I don't know. I hate giving the I don't know answer. But I guess, in theory, anything can be a discriminatory practice. If you believe, they're doing it because you participated in an investigation, could it be discriminatory? Maybe. But again, we determine that through an investigation. Just because something appears discrimination doesn't mean it is. So it's really hard for us to say blatantly whether something is discriminatory or not.
All right. Well, that sums up the questions. If any of you that are still on have questions, like he said, you can contact their office. There's an email address and a phone number listed. Other than that, thank you so much for presenting, Mike.
Thank you.
And thank you all for attending today's session. And we will look forward to seeing you next week. And again, if anybody needs participation certificates, please reach out to Marilyn and she will get that sent to you. Other than that, I hope everybody has a good rest of their afternoon. And those of you that want to attend next week, we'll see you next week. Thank you.